Hello, everyone, and thank you for joining this Use Laboris webinar. My name is Isadora, and I'll be facilitating the session for you today. This webinar will be given by a set of panelists, all from different member firms of Use Laboris. Today, we have lawyers from Brazil, Chile, Mexico, and United States. Okay, that's all from me. I will now turn over to Luis Alvarez to begin the session. Go ahead, Luis. You're welcome to start.
Many thanks, Isa. Nice to see you all and happy to discuss about this interesting matter. So, well, regarding M&A transactions and the prior due diligence that should be carried, well, there is no doubt that due diligence are critical to understand and confirm the status of a company that is the target to be acquired, and the due diligence is pretty relevant in order to determine the healthiness of a company. So, and to understand if it is the case, the level of liability that may impact if we acquire a company. So, however, as you will see with my colleagues, there are so much elements that we will need to confirm during the due diligence in order to evaluate how the company's healthy is. So, in a nutshell, I think we can even though there are a lot of elements that we will need to review, that we can summarize this in three basic points. Now, however, prior to these three important points, we will need to understand, and it will be critical to confirm, and especially for some jurisdictions as it may vary, if the transaction is an asset or a stock purchase. So that will be very relevant, and you will see along the conference. So, however, and also very important is to understand timing. Also, timing is very important. Sometimes and who we are representing, whether we represent the seller, the buyer. We will need to have some type of perspective and postures in order to determine how to act and how to counsel our clients. So in this regard, and timing, as I was saying, it's very important, since if we have a tight time, we need to focus on these 3 points that we're going to discuss. If we have plenty of time, then we will be able to analyze and to give a deep analyze in the scope of the documents that we should review. However, in order to discuss these 3 items, we can resume it in three elements. Obviously, from an employment perspective, one is the unions. Unions in most of the jurisdictions could trigger and could make the transfer of employees, or even the transaction, easier or a tough one. So from a Mexican perspective, union matters are very relevant in order to understand how easy will the transfer of employees and even the transaction will look like. It is also relevant, and my colleagues will elaborate. For example, in Chile, it's also very important to see how the structure of the union is in the target company. So, unions, we need to understand if the union is a very if it's very involved with the employees, or is not a non-active union. So that in Mexico, we can distinguish between a non-active union and an active union. So if the union is a very active one, then we need to take prior steps, prior negotiations with the union in order to determine if we want to keep them or we need to terminate. If we need to terminate them, then we need to have, or we will need to book a specific time in order to make that transition a net one. So unions are always important. Also in Brazil and in the US, this item is very important. The second relevant issue or relevant information that we need to confirm from the target company is whether how, from a benefit perspective, the cost or the estimation cost of the benefits from the employees, because there we have had some experience where there are some specific benefits that are provided to the employees that not necessarily will meet with the companies who is acquiring that entity. They will not meet with the same benefits. Sometimes if the target company has a very specific benefits or just 3 or 4 mandated benefits, that will be easier. But there are some companies that may have a complex structure for benefits that should be understood and should be, and from an economic perspective, we will need to understand how much that will cost for the company who wants to acquire that entity. Now, and the third element that we usually and make a very what we focus on during the due diligence is the employment claims. This is, I think, from a Mexican perspective, we can understand how healthy a company is based on the number of claims that a company may have. If they have minimum claims, then we can say, well, I mean, we can say that it's a healthy one. However, we also need to confirm before the labor authority if the information that has been provided it's accurate. However, also from a U.S. perspective, it is critical to understand and to have to confirm from the last 3 years how many claims have been in place as well in Chile and Brazil. No? So that those 3 items are the most important from a Mexican perspective. However, I think also from the other jurisdiction could be the key items that should be reviewed. No? We will also need to understand what are the legal consequences depending on the type of transaction, whether if it's an asset or a stock purchase. From a Mexican perspective, it is easier to conduct a purchase, to conduct a stock purchase because the company will remain the same. So there will be no need to transfer any employee. Also, the term that from a Mexican, Brazilian, and Chile's perspective, it is critical that when we transfer the employees from one entity to another, that the same terms and conditions of employment remain. However, as an exemption, and Marcela can elaborate, in Chile, you can agree to change the terms and conditions of employment when they are transferred. However, not in Brazil and Mexico. So that is something that the companies should have in mind in order to have a neat transfer of employees. Also, for example, it is always important to determine if there is a duty to consult or not to the impacted employees. In Mexico, there is no duty to consult. However, there is a duty to notice about the transfer through a letter that we call employer substitution letter, where we only deliver it to the employee in order to let them know that the transfer has been conducted and who will be their new employer. So those kind of things we should address before or during the due diligence in order to understand and make the transfer of employees in a very neat way. Now, in the US, for example, employment at will is the general basis where the employer can terminate someone without any reason, and the same as the employee can terminate the employment relationship. In Mexico and in Latin American countries, that is something that it's very different, and sometimes as these Latin American jurisdictions are very pro-employee, so sometimes we have a lot of prior steps in order to terminate or in order to enter into negotiations with impacted employees in order to avoid litigation. Also, during these type of transactions, it is always important to have in mind that that data is very important. Data protection laws in most of our jurisdictions are very heavy, and it's important to look on those items. And finally, COVID-19 has also been a relevant matter in order to make sure that the company that we are acquiring are complying with COVID-19 measures. So in a general way, that will be the general red flags that we recommend to look at. And now we can go to the some of the questions that have been raised. So for Brazil, Sylvia, there's a question. Do the buyer's responsibilities for past liabilities change depending on whether it is a share or an asset deal? That will be the question.
Well, as a rule, no, Luis, because both in case of asset or shares deal, the buyer becomes responsible for the employment agreements currently in effect, and also for any employment liability related to the period before acquisition, including the employment agreements terminated before the M&A. So all is buyer responsibility. What we see in practice that is different in case of an asset deal, because it normally involves acquisition of one part of the seller's business, but the seller continues to operate the rest of its business. So there may be a discussion if what part will be responsibility of the buyer and what will be the responsibility of the seller. And there is a court precedent applicable in Brazil for when we are acquiring a company of a group of companies, but it can be applied by analogy for this case of acquiring a part of an asset of a company. And saying that in this case, provided that the seller is solvent, and this is not a fraud, of course, the buyer will be responsible only for those employment liabilities associated with the part of the business that he is acquiring. So this is how it works in Brazil.
Great, thank you. There's also a question for Jeff. Jeff, are most employees classified as exempt from the wage hour overtime laws? Oh, you're in mute.
That's the most important question I think a buying company needs to ask, and a due diligence needs to explore, and that is how employees are being classified by the selling company. There are two ways you classify an employee in the United States, either as exempt, and therefore you don't have to pay them overtime when they work more than 40 hours in a work week. And to answer your question more specific, Luis, the overwhelming majority of employees ought to be non-exempt, and non-exempt employees are those that are entitled to be paid overtime, which is generally speaking time and a half for all hours worked more than 40. And what happens in the United States and why it is so important is because we are class and collective action happy here. And there are a lot of class and collective actions brought against employers. And there's a common misunderstanding that if you pay someone a salary, that means that they are not entitled to overtime. And so in order to really make certain that what you're buying isn't a class or collective action, you really need to be focusing on how these employees are being paid by the seller.
Pretty interesting. Thank you, Jeff.
You're welcome.
And there's also a question for Marcela. In case of a business transfer, is it mandatory to sign an employment contract addenda?
No, Luis, it's not mandatory in Chile to sign an employment contract addendum because the rights and obligations of the employees, if all or part of the company or its assets or shares are transferred, it occurs by law. However, for reasons of order and clarity, it's highly advisable to sign or to execute an employment contract annex, leaving on record the full name of the employer and the fact that the transfer has been made in accordance with the law. The execution of this annex reduces future contingencies or liabilities, such as eventual labor claims from employees against the former employer. So even if it's not mandatory, it's highly recommendable to execute this annex.
Interesting. Thank you. I think we have those questions for now. So
okay, so my turn. Let's talk about the unions in M&As. Hello, everyone. Good morning or good afternoon. Well, let's start with the prior consultation and notes for unions. In Brazil and Chile, no prior consultation with unions is required for transfer of employees in case of M&A. In Brazil, the collective bargaining agreement may determine differently, but this is not unusual. So as a rule, it's not required to consult the union. In Mexico, no union consultation is required if it is an share deal, but if it is an asset deal, it's required to issue, as we told you, and in a substitution of employer notes to the employees and to the union. This is not request for consent, but these notes must be executed by both the seller and the buyer, and it must be agreed before the labor board. So it's a more complex process. One important thing when we talk about Brazil is mass dismissals. And it's a point that may be important for seller side. Because in Brazil, until the labor reform that was in 2017, the law was silent about mass termination. And the cases were all decided based on a non-binding precedent by our Superior Labor Court, determining that employers must discuss the terms and conditions of that dismissal to mitigate the social impact of that. The precedent does not define how many employees would qualify a mass dismissal, but the decisions we have that are favorable to unions, it's related normally to layoffs involving 15 employees or more. But the labor reform in 2017 changed that. And a new provision in our laws was included to say that mass dismissal is equivalent to individual dismissal. And you can terminate without any union agreement and without any union negotiation. But of course, it's changed completely the court's interpretation so far. And because of that, today, even after the very clear provision in our labor code, we have some judges deciding that the negotiation with the unions in case of mass dismissal is necessary. This is a controversial issue in Brazil. This is something that there is a lawsuit to be decided by our Supreme Court. It's expected to be decided this year. And when it is decided, it will be binding for all the other courts. But this is important aspect to be considered by sellers, because sometimes the buyer does not want to hire everybody or wants to hire only part of that. And if it as a consequence, it's necessary a mass dismissal, those aspects must be considered. And for collective bargaining agreements in all the countries, in Chile, the collective bargaining agreement, the CBA, will continue to be applicable with the new employer. And said CBA may protect union members with immunity of dismissal, in which case dismissal is only possible by a court order. So this is a very specific point to be reviewed in the due diligence. And in Brazil, it's different because the CBA is defined considering the employer location and the core business. So if the buyer has a different core business or a different location and a different union will be applicable, and as a consequence, there will be a different CBA. So in this case, the buyer may have a different CBA, and the employees will not be entitled to the seller CBA anymore. In Mexico, the CBA process is more complex, as Luis has explained a little bit. The buyer must decide to keep the same union or to change it. And if it is the same union, the buyer must execute an agreement before the labor authority to transfer the CBA. And if it is a different union, it's necessary to negotiate with the seller's union to terminate the CBA. So it's an active procedure to be taken by the buyer and by the seller. And now for questions, I will start with Jeff to ask about how it works about CBA in the USA. Will the buyer be bound by the collective bargaining agreement between the seller and the union or not? Jeff.
Thank you, Sylvia. The answer is it depends, and it depends on the type of transaction, and it can also depend upon whether the employer who is buying is considered the successor employer. And the type of transaction, if you're essentially having the same employees or most of the same employees do the same work when you are buying some or all of the company, then there's at least a good chance that you may be a successor employer. And then if you're a successor employer, you have, generally speaking, the right to set initial terms and conditions of employment without having to first bargain with the union. But then as a successor employer, you must bargain over any changes to those initial terms as part of your bargaining obligation. Of course, in the United States, a successor employer, depending on the relationship with the union, may, in certain circumstances, be bound by a predecessor employer's collective bargaining agreement if they expressly accept to do so. And sometimes based on their conduct and implicitly accepting. But it is by no means a given that you have to necessarily even be bound or that you are a successor employer. And I think one thing goes without saying, but is not necessarily the case with my colleagues here. Unionization in the United States has diminished continuously over the past several decades, so that I think maybe 7 or 8% of private employers are unionized and majority are not. So more often than not, we're not dealing with the traditional labor issues that my colleagues are.
Very good, Jeff. Thank you. And Marcela, in Chile, talking about the immunity privilege, how it works, which union members are protected from dismissal by the CBA?
Thank you, Sylvia. As you have mentioned, collective bargaining agreements remain in effect. So with the new employer, so the union, the directors are protected under immunity of privilege, and the union members that are protected from dismissal are employees joining to form a union from 10 days prior to constitution of the union to 30 days after constitution, candidates for a union director position from the time the election date is set until the election is completed with a maximum period of 15 days, union directors and directors of federations, confederations, and workers' centers during the term of office, and for 6 months thereafter. Also, employees involved in collective bargaining process for a period starting 10 days before bargaining and ending 30 days after bargaining. So that's very interesting. And finally, employees members of the Joint Health and Safety Committee until the end of his or her duties as the employee representative of this committee. So it's very important to bear in mind what if there's any union member with immunity of dismissal in any due diligence to take into consideration. Yes.
Okay, thank you, Marcela. And for you, Luis, as we talked about the transfer in Mexico, about the CBA, can you explain a little bit, do collective bargaining agreement transfer, and how is the process to transfer it? How complex is it?
Thank you. Yes. It depends on the type of a union in order to understand how complex could be the transfer of the CBA, and or if needed to terminate that that CBA, because I mean the general rule is that the same CBA must be transferred as well or within the employees in order to maintain or to keep the same terms and conditions of employment. However, it is usual that the buyer doesn't want such a specific union, and probably it has another union that has been working with that company or group of companies. So from a legal perspective, the union and the CBA will carry over with the transfer. However, in order to be effective, legally effective, an agreement, a substitution agreement, must be in place before the labor board in order to have those legal effects. In full effect. However, if there is a need to terminate the contract, then prior negotiations must take place, because as a general rule is that the CBA will be transferred, then there will be a need in order to negotiate with the current union in order to terminate and to create and produce a new one with another different union. However, it is critical that even though the union is not the same, that the same terms and conditions of the agreement remains with the new employer. So that would be the general rule, and that change will also need to be applied or noticed before the labor board.
Okay, very good. Thank you. Okay, so thank you all for this discussion about the union's participation in M&A, and I think now is Marcela to talk about compensation.
Thank you, Sylvia. Now we can see the slides. Yes. Well, in any reorganization and restructuring process in Chile, all individual rights must be strictly protected and cannot be modified by any means except by the agreement between the employer and employee, as you have mentioned very well, Luis. In fact, pursuant our Article 4, Paragraph 2 of the Chilean Labor Code, the total or partial modifications with regard to the ownership, possession, or mere tenancy of the company will not modify the rights and obligations of the employees arising out of their individual employment contracts or the collective bargaining contracts, as you have also mentioned, Sylvia. they will maintain their effectiveness and continuity with the new employer. So this is a very important fact to take into consideration. Thus, employment contracts would not terminate as a result of the transfer business, but the new entity assumes all the labor obligations, including employees' compensation. This rule applies in the same terms, for example, in cases such as merger of companies, sale of shares of a company, split of a company into a third entity, mergers, acquisition of all the operative assets, acquisition of part of assets and liabilities, lease of the company, sale of machinery, etc. Under this scenario, the employees in Chile maintain seniority as well as the rights and obligations under the employment agreements and practices in place with the former company, which must be honored by the new employer. Same rules applies in Mexico, where all existing terms and conditions of employment, including but not limited to seniority and any contractual or acquired benefit, must be fully honored as originally agreed with the former employer. In Brazil, it's quite similar, as automatic transfer of employees occurs when the deal is made between companies of the same economic group, or if it's a case of companies of employers' succession because of asset or shares deal. Then in Chile, Mexico, and Brazil,
I think maybe, hi Marcela, I think maybe you had a problem with your connection.
Oh, sorry. Can you hear me well?
Yes.
Now?
Sorry about
sorry.
that. No problem.
Yeah. Well, I was saying that in Chile, Mexico, and Brazil, no termination fees are due by the new employer to the employee at the transfer date, but termination fees paid in the future will consider seniority and rights accrued by the employees. Therefore, it's highly advisable to check employee seniority, any severance compensation agreed, and offer letters that make certain promises commonly used in the US, for example, to consider future costs for termination. In fact, this is a relevant matter on top executive employment contracts, as on many occasions, the severance compensation tends to be beyond the legal ones. Moreover, it's also crucial to check and confirm if they have any particular conditions set forth in case of dismissals. Nevertheless, in some deals, either in Chile and Brazil, for example, seller and buyers agree that the seller must terminate the employment contracts with this employee and pay all the severance before the closing. Same happens in Mexico when the new employer intends to change existing terms and conditions of employment, then the fire and hire option can be implemented to engage employees under different conditions. So the former employer terminates the employment relationship and the new employer rehires the employees with no pending rights or obligations. This is also a way in which the new employer may avoid unwanted liabilities and started with a fresh page. This also may be beneficial for employees as they will receive severance and pending accrued rights before starting off with the new employer. If the seller and buyer agree that the seller must terminate the employment contracts with its employee before the closing, the employer should terminate the employment contract in Chile with its employees signing the relevant employment contract release and paying all severance compensation. In Chile, if the employment contract is terminated on the grounds of company need, the employer shall pay the employee compensation based on the number of years worked. And the general rule in Chile is that the payment is the payment of the last monthly salary for each year work or for the portions of time upper than 6 months. However, this amount has two significant limitations. It may not exceed 11 months, and the amount of the remuneration for the proposals may not exceed the limit of 90 infection indexed units. Today, it's approximately $3,300 US. However, this rule applies unless the parties have agreed a different compensation in a labor contract or any other document. In addition, the employer shall pay a compensation in lieu of previous notice, which also has a limit of 90 infection indexed units, unless the parties have agreed a different thing. However, if the employer notifies the employees of the termination contract with a month in advance, it's not mandatory for the company the payment of this compensation in lieu of previous notice. Moreover, the employer shall pay all pending vacation days and all the accrued wages or remunerations, if any. In the case of Brazil, termination fees are based on seniority and salary. Prior notice indemnification can be up to 90 days of salary, and severance can be equivalent to approximately 40% of monthly salary per year of work. Finally, once the employment contract is terminated and all severance compensations are paid, the new employer and employee shall execute a new employment contract with the new terms and conditions they decide. Now I do have some questions for you for each country regarding employee compensations. I would like to start with Sylvia in Brazil. Does the choice between transfer or termination of employment impact the buyer's responsibilities for past liability?
Well, no, Marcela, this is a common question in Brazil, but you know, even if it is an asset deal or in a shares deal, and if it is a transfer of a termination, the buyer will become responsible for all the past liabilities. So it doesn't work to terminate the contracts to say, okay, I will start a new one, a fresh relationship with this employee. This is not the case. The buyer will become responsible anyway.
Wow, that's different with Chile then. And for you, Luis, what about employers? Can employers make changes to employment contracts? And if they can, what are the implications for that?
Yeah, that's also an excellent question. I mean, it depends, and because as the general rule is that the same terms and conditions of employment must remain unless these benefits are integrated way. However, it is also common that we have companies that provide different benefits that at the end of the day will be very similar or may balance the total compensation. So if the new employer is able to reflect that these changes are in the same level or even greater, then those changes can be applied. Now, if there is a very large gap between prior benefits and the intended benefits to be provided, then as an option, as you were saying, in order to avoid carrying over these liabilities, an option, but it will depend on the type of transaction and how is it set in the purchase agreement. It is feasible to terminate the employees, pay the applicable severance and any relevant payment, and then start a new contract with the new terms and conditions of employment. However, this is not the common rule, as it may trigger a lot of cost. So the most general practice is that the new employer will carry over all the liabilities, and as well as in Brazil and Chile, it's important to confirm the length of time that most of the employees have been working with the target company in order to understand and to have pretty clear the type of liabilities in the event of terminating them. So that would be the general rule.
Thank you very much. And one last question for you, Jeff. Just wanted to know if there are any independent contractors instead of employees. What happens then?
Yeah, so that's probably dovetails nicely with the due diligence conversation we had at the beginning, because along with the classification of either exempt or non-exempt employees, one of the key issues should be, are there a lot of independent contractors? And if there are, that's a red flag that is raised, because our country, and As most people listening to this know, we're very state specific sometimes in how states react. And then we have the country of California, which even does things completely different. But states like California and Massachusetts and New Jersey and a few others have taken really aggressive steps to make it very difficult to even have independent contractors. So if there are independent contractors, be aware. I think somewhat related to that question, but I think it bears repeating, and Luis said it in his initial conversation, remember, we're an at-will employment country with the exception of Montana. And because we have at-will employment, either statutes or common law, that means that unless you're contracting with an employee, there aren't any obligations that flow over. Of course, the other time it may is if there's unionization, but we've talked about that already. But outside the union context, there aren't any subsequent obligations to that employee of the seller unless you agree. And the other exception to that rule is, of course, those executives and management employees that may have a written contract. And if they have a written contract, you need to have that as part of your due diligence. You need to see each of those contracts, see what payouts might be required. There are things called change in control provisions that are often put in executive employment agreements where the executive can get paid out a lot of money if a sale is triggered. So long story short is independent contractors, be aware. And if there are employment agreements, it's typically going to be with executives, and then you just need to read them carefully.
Thank you, Jeff. That's very helpful. Now I pass over you to see what's in place regarding restricted covenants.
Great. Well, I think as with most of the other issues that we've talked about today, the United States finds itself in a unique position as it relates to their view on restrictive covenants. And following up on what I just said, restrictive covenant law, non-competes, non-solicit of customers, etc., is very, very state specific. There are states like Florida that have a statute that says effectively if an agreement is drafted and it's considered to be too broad by the court is required to rewrite the statute, the non-compete agreement, to make it enforceable, to make it more narrow. And then there are states like California that don't allow non-competes between employers and employees at all. And then there are plenty of states in between, and their approaches on whether or not they're going to be able to rewrite are all over the map. In the context of a sale of business, again, states have their own laws in terms of how they approach restrictive covenants. Many states, I think the overwhelming majority of the states, allow successor clauses in a non-compete that allows a successor employer to step into the shoes of the prior employer and enforce existing non-competes as they were currently drafted. Some states, like Florida, require having a specific successor clause in place in order for that to occur. And I think the most important thing to remember when you're dealing with acquiring a company is, looking carefully at not only the state that you're incorporating in other words, are you buying a company in New York, or do they have headquarter offices in Florida? In other words, when you're drafting this, you might want to try and put in choice of law or forum selection provisions, which dictate one state's laws over another. assuming there's some real connection to that state, because some states are a lot more, as we briefly talked about before, employer friendly in enforcing the agreement. So oftentimes you need to be aware of the state, not only where the employees reside and work, but also where the company that you're acquiring is headquartered. And then realize that each state may have a statute that dictates and controls what discretion a court has to modify an agreement and how broad it can be depending on the context of the agreement and how it was entered into. So for example, I sit here in Atlanta, Georgia, and in Atlanta, Georgia, in the sale of a business non-compete, it can be much more broad, both in terms of the territory that it covers, in terms of how long it can be in place, and even the scope of activity. And so if you're a selling company and you own a substantial portion of the shares of that company, the buying company can tie you up as a former owner into a much broader non-compete than it could its rank and file employees. And so I think it's just important to remember, going back to Luis's initial discussion about due diligence, obviously you need to get your hands on all existing restrictive covenants. If they aren't in place, you need to make certain that you're going to get them in place. Now states, I mean, I'm sure like my sister colleagues on this call, even in the past year, there have been new laws put in place by states in terms of which type of employee can be subject to non-competes and which can't. And we just have to be aware of each state's laws. I know, Marcela, before I ask you my question, I know that Brazil and some of your sister countries will allow, in certain contexts, non-competes. But my understanding is that you must pay the employee fair and adequate compensation for that non-compete, which is something in our country that doesn't exist except for perhaps in New York. That sort of garden pay leave, or garden leave is what the British call it. But my question to you, Sylvia, is in the case of a violation of a restrictive covenant, what are the possible consequences?
Well, Jeff, in Brazil, indemnification is the usual solution. You know, courts tend to reject to give an order prohibiting someone to work to another company. So it's not impossible, but this is very unusual to get that. So normally it's only about paying an indemnification, and indemnification for damages. You know, Brazil does not have the punitive damages. So you have to prove the damages. So it's very difficult to establish and to prove damages directly caused by breach of non-compete. So because of that, it's very recommendable to have pre-liquidated and indemnifications and fines in the agreement, in the non-compete agreement, to be able to receive that in the future, instead of having a proof of what were the damages and how much they were.
That's very interesting, and completely opposite of the United States, where liquidated damages are often found to be penalty damages and therefore not enforceable. So it is quite interesting that we have different. And Sylvia, in Chile, again, my understanding is, while there are no labor rules expressly regulating restrictive covenants, but you have the Chilean constitution that protects an employee's freedom to work and the right to develop any economic activity. My understanding is similar to Brazil. if you're going to have a restrictive covenant in place, you must pay for it. What happens if there is no non-compete clause in place? What do you do then?
Thank you, Jeff. Well, if you have no compete clauses, the employee is free to enter into service with a direct competitor or to start his or her own competing business. In addition, the employee may work in the same market and with customers of the former employer. The employee will only be liable for damages if he or she acts wrongfully against the former employer, notably in situations of unfair competition, of course. And the burden of proof of a wrongful act, it rests with the former employer. So yeah, it's quite different from what happens in the US and in other jurisdictions.
Thank you. And Luis, I am going to save the best for last, right? Mexico. But one of my thoughts again is my understanding that there is a general rule that really disfavors non-competes, which is similar to the United States. And yet we have a wide variety of ability to enforce it. Again, my understanding is that you would have to pay for a non-compete if you're going to have it in place. But my question to you really is, can you ask, because it's my understanding there is some issue of this, can you ask employees whether they are subject to any non-competes or non-disclosure provisions, or is there some restriction on your ability to do so?
Thank you, Jeff. Yes, as you wisely said, one, the labor law, it's pro-employee and employee protective. Also, from a constitutional perspective, there is a protection on the freedom to work, as you were saying. However, it's very common to execute this type of covenants in Mexico. So the answer will be yes. The short answer will be yes. Employers may ask employees whether to confirm if there is an agreement, a non-compete or a non-solicitation agreement that may impede the employee to provide services or work. So there is no specific rule or even provision in the law that would limit any company to ask for this.
Great, thank you so much. Well, that's all that I have, and I know on behalf of all of us, we certainly appreciate you guys tuning in to our Zoom conference, and I'll turn it over, it looks like, to any questions that we might have before we eat up our entire hour.
Yes, Jeff. Let me check here the questions from the audience. And then Marcela, I have a questions for you about in Chile. How is the procedure for collective redundancies and or mass dismissal? How does it work if the seller needs to terminate a group of employees?
Yeah, well, thank you, Silva. There are no special procedures for collective or procedures or obligations for employers for collective redundancies. They do not exist in Chile. And the rules of individual dismissal must be applied in these cases.
And Luis, can you tell us how is in our country, how is in Mexico, the mass dismissal, how does it work?
Absolutely. Yes, it is pretty similar as in Chile. There are no specific rules for redundancies or mass terminations, as long as we comply with the severance package, which in general terms, and Jeff may confirm, it's very generous. Unlikely that could happen that in the US. So as long as we have those package duly paid to the impacted employees, then everything will go on a very neat way. So, and the worst case scenario is that any of these impacted employees may contest such termination and will end on litigation. But it will be a straightforward process. No restriction for those.
Okay, thank you. Okay, so thank you. Those are the questions. Now I think we turn to housekeeping.
Yes,
To
Sylvia.
Isadora.
Thank you. Thank you. For any further questions that you might have, our panelists will remain available by email. Please check the slides for their contact details. And for more information on our webinars, you can visit the webinar section of our website. There, you will find past recordings and download the slide decks. Don't forget to check our podcast, Talking Work, in which we talk about the world of work. Finally, I would like to thank everyone for attending, and thanks also to our panelists for their insights. So with that, this webinar will now be ending. Thank you. Have a good rest of the day. Bye-bye.
Thank you.
Thank you. Bye-bye.
Bye.